Greetings to you, students. Congratulations for having made it to this far with your studies. You are about to finish your studies. I am Advocate Sogone, and I will be taking you through in this semester on the Legal Practice B. I hope everyone is registered for this semester. Make sure that you are registered so that you don't waste your time coming to class and yet you are not registered. Remember, there are two codes. You must register yourself in one of the codes. Okay, we will start with we'll have to start with what is named the letter of demand, right? What is a letter of demand? And remember, we're here now. Let us forget about criminal procedure. We are doing civil procedure. You need to know exactly what happens when you have a civil matter that has to be brought to the magistrate court, or that has to be brought to the high court, or even the small claims court. Right, I will give you a special lecture. I have a special lecture on small claims court. If you look at my YouTube channel, you will find a lot of material dealing with small claims. But for your sake, I will just repeat it, but not now. For now, let us deal with the normal civil claim. Say a person owes you 62,000 rands and you want to start an action, right? So now I want you guys to be very careful when we talk of action and we talk of application. You must be able to distinguish those two differences. Action is proceeded with in another manner, as well as application. First of all, let us clarify this. For action, we will have a plaintiff and a defendant, right? And for application, it will be an applicant and a respondent. So you must know those differences. Do not go about and saying the plaintiff and the respondent. It doesn't work like that. Plaintiff, once you say plaintiff, that is action proceedings. Once you say applicant, then that is an application, right? Okay, it's not action. It's an application because there's an applicant and a respondent. So you must make those differences. I've seen that most of your students do not know the difference between a plaintiff and an applicant. So you've got that distinction now. Don't make that mistake. It is very important. Once you draft papers and you cannot distinguish between an applicant and a plaintiff, then your opponents will start judging you to say, this one doesn't know what she or he is talking about. So be careful. Do not embarrass me by doing an application and say that the plaintiff is doing that. There's no plaintiff in an application, and there is no applicant in an action. Okay, I think I've made myself clear. So how do you start an action, right? This is how you start an action. You start an action with a letter of demand, right? Normally, a letter of demand will give the other side 14 days to respond, where you will be saying exactly what is it that you want your opponent to do or the defendant to do. In this case, we've said this person owes you 62,000 rand, and let us also talk about jurisdiction as well. Once you've done your letter of demand and the person has not responded, the next step will be for you now to draft what is called combined summons. Okay, what do I mean by combined summons? There is something called simple summons and combined summons. Okay, let us deal with combined summons. because obviously I don't have to go to simple summons because they will be the opposite of that, right? Combined summons will be where you start an action and you give the other side time to respond, right? Normally you will give them 10 days to file a notice to defend, right? It will be a notice to defend. Be careful now, because when we talk of application, it won't be a notice to defend. It will be a notice to oppose. So you must make those decisions. Be careful not to mix them, right? After you have done your combined summons, right? Your combined summons should give your defendant 10 days to file the notice of intention to defend. And then in those summons, you will also add that the defendant must file a plea, because this is what is going to happen. You will draft your summons, and in your summons, you will have, they say combined, because there will be a portion where you tell them about the days, and also you tell them about when to file the intention to defend, when to file the plea. Okay, that's the first part. The second part is where now you give what is called the particulars of claim. Particulars of claim will be a separate page combined with the first page, where you will be instructing the clerk of court, the sheriff, and to go and deliver summons to this particular defendant, right? And giving days, so that if they don't respond, then you will take the next step, right? And then the next step becomes the application. Then you become an application in the same course of action where you were a plaintiff. There was a plaintiff and a defendant. Then it's going to change, and there's going to be what? There's going to be an applicant and a respondent, because now you will be applying for what is called default judgment, and you will be applying for something called summary judgment. There you become an applicant. So be careful now how you utilize these terms interchangeable. So once you have given the opponents 10 days and they fail to respond, what do you do next? What you do next is now for you to make an application for default judgment, because they have not responded or filed their intention to defend. Sometimes you'll find that your opponent, the defendant, will file an intention to defend, and you know that these people have got no case, right? What do you do next? You file for an application for a summary judgment and state that the defendant has got no defense in law. He is just filing an intention to defend, thus to waste the court's time or waste your time or to prolong the action. You can do that. Also, if your defendant files an intention to defend but fails after 10 days, after 10 days, or no, say after 20 days after they have filed an intention to defend, they fail to file their plea, right? Their plea, what is a plea? A plea will be that document where you will be answering, denying, or agreeing to, or say admitting the allegations in the particulars of claim, where the person will be saying the plaintiff is Nomusa Kangile, a black female residing at, then you have to respond to that. And then they'll say that the defendant is Bongani Kumalo, an African male residing at such and such an address, employed by this company. That's what we'll be saying. And then they will even say the court has jurisdiction. And then they will say, on such and such a day, you borrowed so much money, and now you have failed to pay the money. And then they'll continue to say, therefore, you are in breach of a contract. Now they want that that money to be paid, or the contract to be set aside, and that you'll be forced to do what? To pay the amount. So you will be responding to all those allegations that are contained in the particulars of claim. You will be starting whatever whatever paragraph, because the particulars of claim are to be in paragraph. I would love that when you do particulars of claim, you start with, you write number 1 at the center of the page, and then you start at the beginning of the page and say the plaintiff is so and so, and then you come to paragraph 2, you say the defendant is so and so reciting it, and then you come to paragraph 3, write number 3 on the center of the page, and you say the court has jurisdiction, and then you continue like that. Now, when you are doing a plea, now let's say you are now the defendant in this matter, you will have to address each and every paragraph, right? Whether you are denying it or you are admitting it, right? So you don't have to deny that the plaintiff is so and so, because you know the person, and that you cannot deny that you are the defendant. So you will say paragraph 1 and 2. So that will be now your first paragraph. Your first paragraph, you're going to be answering, right? You're going to be dealing with 2 paragraphs. So you'll say add paragraph. You've got paragraph. You've got your paragraph 1, right? And then you say at the beginning of your page, you say add paragraph 1 and 2 in the particulars of claim are admitted, right? So you have dealt with 2 paragraphs, which is 1 and 2, where it says you are the plaintiff and the other guy is the defendant, right? You can even add the one that says jurisdiction. If you got no problem with jurisdiction, then you can say also that the jurisdiction is admitted. That means now you will say add. Add will be, you'll just write AD, right? Say you're actually saying addressing paragraph 1, 2, 3, and then you give an answer that says they are admitted. That is how you do it. And then you will come, now your paragraph 2 will be dealing with your plaintiff's paragraph 4, because you have admitted the first 3 paragraphs in 1 paragraph. Then you'll say your paragraph 2, but now you're addressing, you say add paragraph 4, because you are dealing with paragraph 4. It's either you deny it and or else you are admitting it. So that is how you draft your plea. Okay, and then at the end of your plea, you will then say your prayer as well, whether you want this matter to be dismissed or you are admitting everything and you are prepared to pay. So you'll do that. But I will show you how it's done when we get into class. Okay. Now, let us say now the other party did not file an intention to defend, and you haven't filed a plea. What do you do next? What you do next, the next step now will be something called the notice of bar, right? You will file a notice of bar where you are saying a person was given 10 days to file the plea, he failed. He was given the 20 days to file, the 10 days first to file the intention to defend, and then 20 days to file the plea, and the person failed to do that. That is now the defendant. So what do you do next? And then you send a notice of bar. That means you will say the person is ipso facto barred, right? You'll say you were given so many days and you did not respond to it, so you are now ipso facto barred. Yes, so if the defendant fails to file the intention to defend also fails to file the plea. So you go to the next step, which is now you become an applicant. You apply for default judgment because he has failed to file a notice to defend. And then if he has filed a notice to defend but failed to file a plea, then you go for what is called an application for summary judgment, right? So you'll get your judgment, and the defendant will be forced to pay the 62,000 rand and also pay the cost because we have employed lawyers. So you'll go and do that. And there's something called a taxing master, right? Somebody in court who's called tax master. We will deal with that later on. But now let us now go to what happens now. Say you are the defendant and somebody has done that. You failed to do your intention to defend. You failed to file your plea. So what do you do now if you still want to respond to this action? We've got something called the interlocutory applications. Interlocutory applications are those applications that you do in the midst of your action, including summary judgment, default judgment, notice to compel, a notice of exception. Sometimes somebody will bring an action against you, and you will file a notice of exception and say, but I paid this amount. I don't know what this person is talking about. Or I am not the person that is mentioned in this summons, right? Or maybe you will file a notice of exception where say a bank gets into a contract with your wife and your wife fails to pay, and she is not working. You are the one that's working. What they will do, they'll say, because you are married in commute of property, you must be the one that's paying the debt. So what I normally advise my clients is that once the bank does that, you can now invoke Section 15 of the Marital Property Act, right? You invoke that act. That act, if you look at Section 15 of that act, it will tell you about the powers of spouses. And it will say, if you look at subsection 2, paragraph F, it will say anybody who enters into a contract with somebody who is married in commute of property the other spouse has to consent in writing, right? So if there is no consent letter from a spouse that says that institution can get into a contract with your spouse, then you can invoke that and say that agreement is void because no consent was obtained from you. So in other words, you'll say you cannot pay because the contract is actually void. Is it void or voidable? I think it's void. So you can, that's an exception. You say, oh, this is done. Okay, let's do an exception. Okay. You can also make another application that is called the irregular step. It's Rule 28 of the uniform rules. If you look at it, it will tell you of irregular step, that a person has performed an irregular step, and you ask the court to dismiss that whole action as an exception, right? Because when you do an exception, you actually want to speed up the process or to dismiss or to force the other party to comply with your prayer, right? Okay. Now, how do you then, what else can you do? Okay, you will do, if you're a defendant now, what you can also do is to do something called application for rescission, right? Application for rescission, then you will give reasons as to why do you want that judgment to be rescinded. It's either you'll say you were not properly informed about the action against you, and in that effect you must also say that even there is no return of service, because if there's an action against you, the sheriff will have to come to you and make you sign and do what is called a return of service, which is a sheriff telling the court that in this action, summons were served, the other party knows that there is a case pending. But if for whatever reason you don't know anything, there were no papers served to you, because sometimes they have a tendency of serving summons through the post office, thinking that you will receive that that small paper that calls you to come and collect your parcel, and you don't do it. That means you don't know. So this principle of the doctrine of audi alteram partem is not applicable, and for that reason you can apply for rescission. Okay. Sometimes you can also apply for something called condonation, right? An application to condone your late filing of your intention to defend and plea. You can do that, right? Those are the interlocutory applications that you can do in an action. Okay, you can also interdict an application. Somebody does this thing application against you, and then you interdict it. There's something called a mandament van spolie application that you can do, where sometimes banks have got a tendency of seeing that you are not paying for 2 months. They will come and just grab the vehicle. They say they are taking it for safekeeping. Then there you have a right to do what is called mandament van spolie. You know that the vehicle doesn't belong to you until you have finished paying, but nobody has a right to come and take it from you. It's the same thing. If you can prove that you were in peaceful possession of the property, then you have a right to do what's called a spoliation order. Apply for a spoliation order. Okay, let us leave it there. And I will be expecting you guys to ask me questions when we meet next week. For now, let us hold it there. That's enough for today.